So you've been hired, you've been injured, and now your claim is denied. And why is your claim denied? There's lots of reasons why. We're going through a bunch of them in this series about why did the insurance company deny my claim. And today we're going to talk about a weird category of denials, which is when you're working but you're not covered under workers' compensation. There are a few weird exceptions. We're going to talk about it today. Hi, thanks for joining me. My name is Kaplan Morrell. I'm an attorney with Kaplan Morrell. We are attorneys in Colorado helping injured and disabled workers. We've been doing that as a firm since 1997, and I personally have been helping injured workers since 1995. Thank you so much for joining me. Today we're discussing why do insurance companies deny work injury claims in Colorado, and there's a whole host of reasons, but there's a weird category, which is certain things that you do, even if you're doing them on the clock, on the job, etc., just aren't covered. And we're going to talk about three of them today. One of the weird exceptions to workers' compensation laws in Colorado is certain activities, even if they're promoted by the employer, are not covered under workers' compensation. And the first one is voluntary participation in what are called recreational activities. So what does that mean? Often employers will do things, set up situations, set up group events, team building events that are voluntary, meaning you can attend it or not as you wish. Sometimes those can even be on the clock. So let's say your employer says, hey, we're all going to get together for a volleyball game. We're all going to do a bike ride, or let's all, get fit for the year and let's walk around the block, etc. And even if your employer sponsors it, compensates it, and pays for it, and you get injured during that activity, it's not covered under workers' compensation. It's a carve-out. It's an exception to the rule. I had a case where my client was attending a conference, and as a result, she and other coworkers flew out to another state, and they attended a conference that lasted, Monday through Friday, etc. Now, you can imagine, you're in another state, you're in a beautiful place. Let's say you went to Boston, right? What are you going to do if you're traveling to Boston? You're going to go sightsee, right? You're going to go, I'm going to go walk the Liberty Trail. I'm going to go see Boston Harbor. I'm going to go see all the sights, right? Well, that is recreational activity. And the general rule, if you're on a business trip, for example, is look, anything that happens during that trip is going to be covered under workers' compensation. Plane goes down, God forbid, it's covered under workers' compensation. If you choke at dinner or you get food poisoning at dinner, covered under workers' compensation. If you trip on the way to the conference or on the way back from the conference, covered under workers' compensation. It's all covered except for what are called recreational activities. That is a carve-out. I mean, even if you, for example, got injured sleeping, right? You're just sleeping in your bed in the hotel room and the hotel collapses, God forbid. Your injuries are going to be covered under workers' compensation. But recreational activities are this weird carve-out. And so my client, she got injured walking through a park, which was a big tourist destination of this area, and the question was she injured on a recreational activity, i.e. sightseeing, or was she injured walking to get lunch? If she was injured walking to get lunch, covered. Walking through the park just to sightsee would not have been covered. So recreational activities, particularly in the terms of business travel, is a big carve-out, but it's not just in business travel. Again, if your employer sponsors a sporting league, a basketball game, an outing to go out to a line dance or go out to a concert, as long as it's voluntary, if you get injured, not covered. Second category is what we call domestic work, okay? So if you've got a nanny, or if you're working as a nanny, or if you're working cleaning a house, or if you are working taking care of an elderly person, or if you come over and you're a cook for a family, or you come in doing the landscaping, you're shoveling the walks, you are mowing the lawn, etc. Typically not covered unless you can show that you're full-time. Then if you are hired on a full-time basis by a household to work, either, again, we see this a lot with nannies, and I see this a lot with at-home assistant for elderly, where the person is living there or stays there, but bottom line, they're working 40 hours a week. Then you're going to be covered under workers' compensation. But if you are just kind of casually there, not full-time, and your employer is just somebody at their private house, it's not part of their business, then it's not going to be covered under workers' compensation, because you won't be considered an employee. Even though you are an employee, it's not covered under workers' compensation because we have carved that out in the statute. Third example, which I run up against a lot, is what we call casual farm and ranch. And so this is, again, kind of this weird exception to the Workers' Compensation Act, where a farm or a ranch can say to somebody, hey, come on over, can you help me for this little thing? And if you get injured, you're not covered as long as the ranch and farm hasn't paid you more than $2,000. They don't have any other employees. It's not part of their other business. It's just kind of casual farm and ranch. But again, if once they pay more than $2,000 during that year, then they do have to be considered an employer and you an employee if you get injured. But this exception is unusual, but typically, again, the ranch or farm has to show that they don't have any other employees and that it's only $2,000 or less during the year. And if that's the case, then even if they hire you and you get injured, it's not covered under workers' compensation. Hopefully this helps you understand that the law is incredibly complex, fact detailed, and sometimes what's weird about the law is you can think you're an employee, but you're not considered an employee under the law. You can think they're your employer, but they're not an employer under the law. There are a number of other weird kind of exceptions to deal with. For example, if you're an inmate working, if you are a student on an internship, are you covered? Yes, you are covered. Inmate working? No, unless it's an employment through some federal statute, etc. Bottom line is, if you have any questions about what your rights are as an injured worker in Colorado, call us. There's a law firm that does this. This is all that we do, and we offer free consultations. I'll put up here how to get in touch with us, 970-356-9898. Comment, like, and subscribe. And as always, thank you for spending part of your day with me. Bye.